All rise. Judge of the B Court is now in session. Judge, this is case number JVB 1039, Sutton case.
Thank you.
You're welcome.
Okay, Ms. Sultan, you're back. And I see that you got, well, dad or potential father served. What's your name, sir?
My name is Stephen Pippin.
Mr. Pippin. Okay, you understand why you are here today, right?
Yeah, unfortunately.
Okay, you know I ordered you to have DNA testing done a month ago.
Yes.
And so we can determine child support, what it's going to be in this case. And I don't have anything from the testing center showing that you...
Buckle up. This case gets messy fast. A determined mother comes to court seeking child support for her 5-month-old baby, while the alleged father, Stephen Pittman, shows up with nothing. No documents, no DNA results, and no preparation. To make things worse, Stephen conveniently quit his $63,000 a year job just after the baby was born. Suspicious. Judge Vonda thinks so. This case isn't just about child support. It's about facing the consequences when you ignore court orders. Let's dive in.
Showed up. So what's going on with that?
Because I didn't take it. I mean, I don't know what she's talking about.
So I order you to do something. This is not about her right now. I order you to do something and you just decide on your own, I'm not going to do it?
Yeah, I mean, I don't think I'm the father, so I don't have to take the DNA test.
Well, if you don't think you're the father, wouldn't it make sense to go ahead and take the DNA test?
Yeah, but I mean, it's all this long process. I'm a busy man. I got a lot of stuff on my plate right now, so I don't have time to sit back and
Well,
just be
how
taking.
busy are you? What do you do?
I'm a waiter.
Oh.
And I'm a full-time student.
Oh, okay.
So I don't have time for the games and all this testing, DNA testing, all that. I don't have time for it.
All right, so you work every day as a waiter?
Yes.
Did you bring anything today to show that you're waiting tables? Any type of financial information?
I ain't bring that.
Oh, so you didn't care about that either. So did you bring anything to show that you're enrolled as a full-time student?
Nah, I ain't bring none of that.
So you just came to court unprepared today and you just think I should go along with that, right?
And if that's what you want to call unprepared, yeah.
When did you start working as a waiter?
About 4 months ago.
What did you do 4 months ago?
I had a full-time job working as a consultant.
All right. How much money were you making?
$63,000.
Hold on. How did you say your baby was?
5 months.
5 months. And you just stopped working there 4 months ago?
Yeah, they had some layoffs, and I kind of thought that they were going to start laying some people off, so I decided to go ahead and quit.
So you quit?
Mm-hmm.
You didn't quit because you figured she was probably going to put you on child support?
Nah, I just...
Things take a turn when Stephen admits he didn't take the court-ordered DNA test. That's a major misstep. In family court, ignoring a DNA order doesn't make the issue disappear. In fact, it backfires. The judge now has legal grounds to declare Stephen the father by default. This isn't a technicality. It's a serious ruling that carries long-term financial consequences. Looks like Stephen's plan to dodge responsibility just collapsed.
Are you sure about that? Because it's mighty funny that this child is 5 months old and you just stopped working that job 4 months ago. How much money were you making?
$63,000.
$63,000 a year? And you're making how much as a waiter?
I did it because I'm a student, so I probably make around $15 an hour.
Oh, no. You came here to waste my time. You obviously came here to waste my time today. I am not going to place you on child support for $15 an hour, and you just start working a job paying you $63,000 a year. You see how crazy that sounds?
I mean, I think it's crazy that you using my $63,000 income. I don't even work there no more.
You don't have to work there, but it sounds like you intentionally stopped working there because you thought she was going to put you on child support.
No.
So you just disappeared on her?
Because I'm not the father. Like, I don't even know. Like, I'm at work.
But we don't know that you're not the father because I ordered you to go and get DNA testing. So we could have found that out today. But you know what? We don't have to do it. You know why? Because I can deem you the father today because I ordered you to do it and you didn't do it.
Judge Vonda starts connecting the dots. The baby is 5 months old and Stephen quit his well-paying job 4 months ago. That timing? Way too convenient. The court pays close attention when someone suddenly lowers their income during a custody or support case. Voluntarily quitting doesn't erase your financial obligations, it raises red flags. Was Stephen trying to game the system? The court certainly thinks so.
That's what we're going to do. That's exactly what we're going to do. So, who carries health insurance? Well, never mind. That was a bad question.
Yeah, it's me.
You carry health insurance.
Yes,
How
ma'am.
much is it?
$750.
$750. Does that include you and the child?
Yes, it does.
Okay. So what I'm going to do is split that in half, because child support, his obligation, he's only responsible to pay health insurance for the child only. Okay. So based on $63,000 a year, I have your monthly gross at $5,250. That brings your net to $4,226.99. How many other children you have? No other children?
No other children.
Well, I hope not. I hope you're not ghosting on them either, because that's exactly what you did to her. So I have your monthly child support obligation at $845 plus $375, which is half of that $750 for health insurance for the child. Your monthly obligation is $1,220.
And just like that, Judge Vonda delivers the verdict. Since Stephen ignored the DNA test, the court officially names him the father. That's what happens when you defy a direct order. No more waiting. No more excuses. In family law, if you don't show up or follow instructions, the court can and will move on without you, and the consequences are very real.
And I'm ordering you to do that. And you don't have any control over that, because that goes through a state agency, and it'll just
I'll
withhold
just
from you.
go ahead and just submit my W-2s whenever I get them. I'll come back.
Oh, okay, that's fine. But today, this is what we're doing, since you came in here unprepared.
Here's the fallout. Stephen is now on the hook for $1,220 a month in child support. And that number isn't based on his new job as a waiter, it's based on his previous $63,000 salary. Why? Because Judge Vonda believes he intentionally downgraded his income. Courts often use your earning potential, not just your current paycheck, when calculating support. Fair or harsh? That's up to you.
Not caring about anything, you don't care about that $1,220 either then, right?
Okay, I guess so. But we'll get updated. I'm not tripping.
Okay, well, we can do that at a later date. Do you have any other questions?
No, I don't got no question.
Okay, do you have any other questions? Okay, if nothing further, you all are dismissed.
Final outcome. Stephen ignored a DNA order, came to court unprepared, and walked away with a hefty monthly child support bill. The court didn't need him to make a ruling, they used his past income to protect the child's interests. This wasn't just a legal decision, it was a wake-up call. Actions have consequences, especially in family court. So, what do you think? Did justice win out, or did Stephen dig his own hole? Drop your thoughts in the comments. And if you're here for real courtroom drama, don't forget to like and subscribe to Truth Court.
Hi guys, it's me, Judge Vonda B. I just wanted to go over what you all witnessed in the Sultan case. So, mom had dad served, dad was served with the paperwork, ordered to take a DNA test and appear in court, and he just decides that he doesn't want to do it. Well, the court can consider that a default. He did show up, he was ordered to do something, he was deemed the father in order to pay child support, and it's that simple.